Good afternoon, my faithful friends at 12 o'clock on Fridays. Today in Ethics in Action, we are going to be covering three articles of the code. Article 7, 8, and 9. So as I usually start this webinar, being a member of the Realtor organization means that you have voluntarily agreed to abide by the Code of Ethics based on professionalism and protection of the public. Realtors also are subject to disciplinary actions and sanctions if they violate the duties imposed by the Code of Ethics. So Articles 7, 8, and 9 are the subjects of today's webinar. Article 7 of the Code of Ethics states that in a transaction, realtors shall not accept compensation from more than one party, even if permitted by law, without disclosure to all parties in the informed consent of the realtor's client or clients. In the state of New Jersey, I know for a fact that this is not allowed by law when involved in a transaction as a dual agent. When working in a single agency situation where you are working either as the seller's agent or the buyer's agent, it is allowed by law to collect compensation from both, as long as both parties are informed and have informed consent, which is what the second part of this sentence says. So when it comes to dual agency, where the transaction is handled both on the seller side and on the buyer side by the same real estate company. So it doesn't matter that it's two different agents. If they're affiliated with the same company, that constitutes dual agency, and that would not be allowed. If the compensation coming from one or the other is different, typically the agent or the broker can choose the compensation that is higher, but they cannot accept compensation from both if it's dual agency. I hope that is clear. When it comes to the case interpretations, there was no standard of practice for Article 7. There is one which basically states acceptance of compensation from a buyer and a seller. And in this particular situation, it was a buyer. The transaction started with a buyer who hired the realtor to locate a small commercial property. The buyer explained the exact specifications, indicating that he did not wish to compromise on what he was looking for. They agreed that if the realtor could locate that property within the buyer's price range, then the buyer would pay a finder's fee to the realtor. Very clear, very easy. 2 weeks later, the realtor called the buyer to advise him that there was a seller, that he had just listed a property from a seller that met all of the buyer's specifications, except that the listed price was a little bit higher than what the buyer wanted to pay. The buyer still inspected the property and liked it, but said he would rather adhere to his original price range. The realtor then called the buyer 3 days later to say that the seller had agreed to sell the property to the buyer at buyer's preferred price. The sale was made, and the realtor collected a commission from the seller and also the finder's fee from the buyer. Now, this finder's fee had not been disclosed to the seller, who was by this point realtor's, the client. Several weeks later, the seller learned about the finder's fee that the realtor had collected from the buyer and filed a complaint with the Board of Realtors, charging the realtor with duplicity and unprofessional conduct. The complaint specified that when the realtor had presented the buyer's offer at less than the listed price, he, the seller, was reluctant to accept it, but the realtor had convinced him that the offer was fair and that he would likely not be improved upon based on the current market, and that the realtor had dwelt at length on certain disadvantages or disadvantageous features of the property in an attempt to promote acceptance of the offer. The complaint also charged that the realtor had actually been the agent of the buyer while holding himself out as the agent of the seller. That is an example that we call illegal dual representation, at least in the state of New Jersey. So further, the seller asserted that the realtor had never mentioned that he was representing the buyer, or that he intended to be compensated by the buyer. At the hearing, the realtor's defense was that he had served both the buyer and the seller faithfully, that he had not accepted the seller's listing until after he had agreed to help the buyer in locating the property, and that in his judgment, the listed price was excessive and the price actually paid for was a fair price. The hearing panel of the Board of Professional Standards Committee, which heard the complaint, concluded that the realtor had acted in violation of Article 7 of the Code of Ethics, and his efforts to represent the buyer and the seller at the same time, and the fact that he intended to be compensated by both parties, should have been fully disclosed to all the parties in advance. That is the only case interpretation of this article, and it actually included illegal dual representation. Now, Article 8 of the Code states that realtors shall keep in a special account in an appropriate financial institution separated from their own funds monies coming into their possession in trust for other persons, such as escrows, trust funds, clients' monies, and other like items. In this particular situation, also, it's very clear, so there is no need for any further explanation. The case interpretation, we actually have two in this situation. The first one is failure to put deposits in a separate account. In this particular case study or case interpretation, the realtor, who was the listing broker, obtained a signed offer to purchase together with the buyer's check for $10,000 as an earnest money deposit. As we all know, the money received that belongs to others has to be put in a separate account, specifically labeled escrow account. And The buyer's offer was subject to the sale of his current residence. The realtor presented the offer to the seller, who accepted the offer. The realtor then inadvertently deposited the earnest money check in his personal checking account rather than the escrow account. Since the buyer's offer was contingent on the sale of the current home, the seller's house remained on the market, waiting for backup offers or additional offers. A week later, the realtor received another offer to purchase in the seller's house from another broker and presented it to the seller as a backup offer. The original buyer, was informed about this new offer and reluctantly concluded that he would be unable to waive the sale contingency or proceed with the purchase of the property. He then asked the realtor for his $10,000 check back. The realtor then explained that he had mistakenly deposited the check into his personal bank account, which had then been attached. When an account is attached, is because there's probably a lawsuit or some kind of a freeze on the account. And so the money is now in the personal bank account, which is not available, and that he would, the money was temporarily unable to be refunded, but he would take care of it as soon as his account was available. The buyer then filed a complaint with the Board of Realtors, which was received by the grievance committee. The grievance committee concluded that the complaint warranted a hearing and referred it to the Professional Standards Committee. At the hearing, the realtor explained that his bank account had been unexpectedly attached or frozen following the loss of a civil suit which he was appealing at the time. That his deposit of the buyer's check in his personal account was a simple error in handling deposit slips, and that he was arranging for the prompt release of his account, and that everything would be straightened out in 3 or 4 days, which should not be of great inconvenience to the buyer. It was the conclusion of the hearing panel that the realtor was in violation of Article 8 for having failed to put the buyer's earnest money deposit in a special account separate from his personal funds. At this point, I have to explain that in addition to being a violation of the Code of Ethics, even if it is an error, something like this can be forwarded or referred to the Real Estate Commission for further action by that body, which in actuality is what happens in the second case interpretation, which is called Request for Investigation, which was filed by the association. This is the Board of Realtors referring the case to the Real Estate Commission. The realtor listed a residential property and sold it to the buyer, who made a substantial deposit subject only to the buyer's mortgage and on terms and conditions not exceeding a specified rate of interest within 60 days. And this is a totally different case, but it's a very similar situation. The realtor assisted the buyer in introducing him to the officials of the lending institution, and after processing the application for a mortgage, a written mortgage commitment was made by the lending institution, which met the terms and conditions of the sales agreement. However, shortly after the mortgage commitment was received by the buyer, the realtor received a certified return receipt requested letter from the buyer advising him that he had changed his mind and would not be going through with the sale. The realtor discussed the matter by phone but the buyer said he would rather forfeit his deposit and definitely would not complete the sale, even at the risk of the seller suing him for specific performance. The realtor then advised the client of, the client is the seller, of the buyer's refusal to go through with the sale, and the seller told the realtor that he did not wish to sue the buyer, but would just accept a portion of the forfeited deposit as specified in the listing agreement between the client, the seller, and the realtor. The realtor then obtained a written release from the sale from the client as well, from the seller as well as the buyer. In other words, he did that right. He got a release making the transaction being forfeited or canceled, and with promise to send the seller a check for the portion of the forfeited deposit that was due to him as had been specified in the listing agreement. However, the realtor failed to send the seller a check, and the client, the seller, filed a complaint with the executive officer of the board, alleging violation of Article 8 of the Code of Ethics. At the hearing, the seller stated that he had no complaint about the services provided by the realtor to him, except for the fact that he had failed to provide a check, a portion of the forfeited deposit that was due to him, and that after several phone calls and letters, the realtor had told him that he would provide the forfeited money just as soon as he could. The client said that the realtor had told him he had some unexpected expenses, and therefore the seller would have to wait until the realtor obtained other funds which he expected to receive shortly. In other words, he spent the money that belonged to other people on unexpected expenses. That is an absolute no-no. The realtor admitted the facts as related and further admitted that he had not placed the deposits received into an escrow account, but had placed it in his general funds account. He said that unexpected expenditures had caused a deficit balance in these funds, and he would pay the seller the money agreed as soon as he could. The hearing panel concluded that the realtor was in violation of Article 8 of the Code of Ethics and recommended that the decision, when final, be forwarded to the State Real Estate Commission as a possible violation of the public trust. The Board of Directors affirmed the decision of the hearing panel, ordered implementation of the recommended sanctions, and requested that the president of the board forward, with advice of board legal counsel, the final decision to the State Real Estate Commission as a possible violation of the public trust. In both of these cases that I mentioned before, the case could have gone to the Real Estate Commission. In the first case that I mentioned before, it was not forwarded, or at least they're not telling us here that it was forwarded. But it could be forwarded. Because any mishandling of clients' funds is considered a violation of the public trust. And definitely the Real Estate Commission would want to know that, and there are sanctions for that. So these two agents could have lost not only their license, but also be found in violation of the Code of Ethics. The next article of the code, Article 9 of the Code of Ethics, states that realtors for the protection of all parties, shall assure whenever possible that all agreements related to real estate transactions, including but not limited to listing agreements, representation agreements, purchase contracts, and leases, are in writing in clear and understandable language, expressing the specific terms, conditions, obligations, and commitments of the parties. A copy of each agreement shall be furnished to each party to such agreements upon their signing or initialing. So there's two things I want to add to that. Not only that we have to get things in writing, but also that we always have to use the most updated documents that are available to protect the legal rights of our clients, whether they are a seller, a buyer, a landlord, a tenant, that we use the most updated documents that are that have all of the legal changes that have happened. In addition to that, the copy doesn't have to be in paper. The copy could be a copy which is sent by email. And of course, because of federal regulations, we should always have authorization of electronic transfer of documents to our clients, which also should be authorized ahead of time. Article 9 does have a standard of practice 1 for the protection of all the parties. Realtors shall use reasonable care to ensure that documents pertaining to the purchase, sale, or lease of real estate are kept current through the use of written extensions or amendments. And this also has to do with any changes that may happen during the transaction, any price changes, any amendments to the contract, any seller concessions, any items that might be left behind by the seller. Absolutely any changes that they should be documented and initialed or signed by both parties. And they become part of the transaction and the documents that have to be kept for record keeping for the duration of the required time by the Real Estate Commission. Standard of Practice 9-2 also states that when assisting or enabling a client or customer in establishing a contractual relationship, such as a listing agreement, a representation agreement for either a property management agreement, a purchase agreement, a lease, or so a contractual relationship electronically, realtors shall make reasonable efforts to explain the nature and disclose the specific terms of the contractual relationship that are being established prior to it being agreed to by a contracting party. So it's not enough for us to just send electronic documents. We actually have to explain what we are sending and make sure they understand the documents that they are going to be signing electronically. Because in the past, we used to sit down with people and go through the contract or the documents. Now, most of our documents go electronically. Buyers and sellers, landlords and tenants may not really understand or be able to read all the legality they're signing, especially if they're doing it on a mobile phone. It's very difficult to read, documents like that. Sometimes there are several pages. And it is still our obligation to make sure they understand what they're signing, either at the time or before they sign them. Article 9 does not have any case interpretations at this time. So we have covered 3 articles today, Article 7, 8, and 9, and their case studies and case interpretations. So it's very important for us not just to know, but to also practice what we know and to always be curious about what any changes that have been happening that could possibly affect our clients and their legal obligations as well as um, their rights. I thank you very much for listening today. I hope you are having a fabulous Friday, and I will see you next week. Thank you so much and have a great day.